the home study reports, the detention report, police reports, medical reports, and then we also take testimonial witnesses, and sometimes the children testify as well, especially in the sexual abuse cases. But what we do in order to protect the children, we will conduct an examination of the children in the court's chambers and not in the courtroom, and we have TV set up so that at least the parents and anyone else who's present can observe the child testify. The attorneys for the county council, for the minors, and for the parents will be in the court's chambers, and so we will conduct the examination in the chambers, and then that's how we'll treat the child to avoid the trauma, and we do it almost on all instances. Then once the court makes a decision, and the level of proof in the dependency is by preponderance of the evidence. Criminal cases, beyond a reasonable doubt. That's a standard of proof. But dependency, it's preponderance of the evidence. Then the court makes a finding that if the court sustains the petition and finds the allegations to be proven, the court then finds the child as someone who falls under the Welfare and Institutions Code and becomes dependent of the court. So then we have a disposition hearing. We could have it then, or we can put it over for a contested disposition.
Okay. And
that gives the parents an opportunity to be heard on the appropriate disposition. Perhaps we want to look at psychiatric reports for both parents, and many times the parents are provided services at the initial detention to start working on the substance abuse issues that they have. Most of our cases are going to involve substance abuse, and if we can get the parents going on that, at least we got. I'm not saying that they necessarily will be released to the parent, but at least we know that the parents should have certain types of visitation. Maybe they can be overnight. And maybe that they need to be monitored, or maybe they don't need to be monitored, but they can still see the children on a regular basis. This is good for the child, of course.
What ages are you normally dealing with? Because for dependency court, and then there's juvenile court, right? So in dependency court,
the dependency court is part of the juvenile system. There's a delinquency, and there's a dependency system that falls within the juvenile department. So these children come within our jurisdiction when they're born, if they're born with drug addiction.
Okay.
So the moment they're born, the doctors will provide a blood test and say this child has been born with meth in its system, heroin, or something of that nature, marijuana. So we will take jurisdiction immediately, and we need to investigate it basically to see the extent of the parents' drug addiction, and maybe it's just an isolated situation. Sometimes a parent is taking codeine, for example, Tylenol codeine, and it's in the child's system. And this was a very isolated. Mom does not really have a drug problem, but as a mandatory reporter, the doctor brings it to the attention of the department, and it has to be investigated.
Oh, I gotta ask you. I gotta tell you about this one. Okay, because now this sounds like where the two, family law and dependency court, might overlap, because there was a case that was presented in family law where the mother and father were getting a divorce. The father accused the mother of having a drug abuse problem. There were something like 20 packets of cocaine, or empty packets found in the baby's diaper at the residence where the mother no longer resided, but she had the children, and so he brought a motion to take the kids away. And so he got custody of the children until the allegations of drug abuse were, I guess, cleared against her. Right. So do the children fall under dependency court in that area?
Yes.
And that's when you get two cases.
Yeah, that we will get referrals over from the family law, and this is unfortunately too common.
Okay.
The parents know to abuse the dependency system by making allegations, and it's all about custody. But we conduct investigation, and then we get a history. We know that these parents, and sometimes it's going back and forth, and of course they caught in the middle of the children. and that's a tragedy.
How many cases do you hear a day?
About 25. But sometimes they're just for
a day.
A day, yeah. We move through them rather quickly. Some of the times it's just a very quick matter. We just review the reports. We do that. I'll do it before court or after court the night before, and I've read it. Everybody's read it, and I'll say I'm going to follow the recommendations. Does anybody want to be heard regarding the recommendations? And usually no. And some of those are the post adjudication hearings that we have. We have after the court has disposed of the case after the trial, then we set it for 6 months for review. Okay. We're looking to see how the child is doing. Okay. We look to see whether or not the parent or parents are complying with the orders of the court and they're working, or whether or not we need to modify. And then we have another 6-month review after that, and it's what they call the 2-1F hearing, because it falls under the Welfare and Institutions Code. And we'll see at that point whether it's time to consider terminating parental rights because the parents are not cooperating. Because we don't want the children to linger in the foster care system. If they're small enough, you want to get them placed into a long-term situation, whether it's adoption or guardianship. But you want to get them out of the system as fast as you can. Get them into a stable environment where some foster parents really don't intend to adopt the children or keep them for a long time. Some are only prepared to handle babies also, so as they grow older. And these children are in a basically system when they're young, and they're not getting all that babies need, the hugs, the smells that they need. So you want to get them in a place as soon as you can where all these things will happen for them. So that's what we're looking at after a year. We may go 18 months where it looks like mom and dad are trying, but they're struggling with their substance abuse issues. As long as you're trying, you still have to keep in mind that you're trying to preserve the family if you can. All right. Then we have, once it's decided that these parents are not going to cut it, they're never going to comply with court orders, it's time to move on to what we call a permanency plan. Okay. And we're thinking now about guardianship, or we're thinking about adoption. And of course, some of these kids come into the system when they're 14, 15 years old, and now we're talking about group homes. We're talking about independent living programs, because it's clear that mom or dad maybe they got incarcerated, they got involved in a criminal case, and now they're not going to be back for years. For years.
You have been fascinating. We're wrapping this up. Murvet and I still had questions. We thank you for joining us from the Halls of Justice, and our special guest. Thank you so much, Judge Rudolph Diaz. And you can find him, I hope you don't have to see him, but he's at the Los Angeles Superior Court, the largest court system in the world. Murvet, thank you for coming.
You're welcome.
Judge Diaz,
thank you very much as well. I had a wonderful time. Thank you very much.
Thank you. Join us next week from the Halls of Justice. I like our music, David picked that up.